Does everybody feel comfortable that they can tell whether or not somebody's lying? Yes from everybody? Yes. Okay, good. Sir, how would you tell if somebody's lying?
If they look around a lot, or if they look somebody straight in the eye when they're saying something.
Just by their physical actions, what they do. Can everybody do that? Can you'll be able to believe some, none, or part of what somebody has to say, and the judge will decide whether or not somebody is telling the truth. Do you think that somebody might have a reason to lie sitting on the stand? Somebody might have an interest in this outcome of this case, right? And they might be comfortable doing that? Okay. Does anybody know, you're going to hear from police witnesses too in this case. Does anybody know a police officer? Raise your hands if you do. Of course. Yeah. I wasn't going to ask that one. I have to. How do you know a police officer?
Through internships mostly.
Okay. Do they always tell the truth?
Yes, sir.
I like him. He's staying. Do you know a police officer?
Yes, sir.
How do you know a police officer? Okay. And do you think police officers always tell the truth?
Yes, sir.
Do they ever make mistakes?
Occasionally.
It's okay. We can be honest. This is the tree. This is safe here. So a police officer can make a mistake. Witness.
Yes, sir.
You are. Okay. Is that going to affect your ability to decide whether, I mean, a police officer, are you going to hold that? Sure. And the judge is going to tell you that you can't. He's innocent. As he sits here right now, he's innocent. It's my job to prove that he did the crime, beyond a reasonable doubt. Who knows what beyond a reasonable doubt means? By a show of hands. Ma'am, what does that mean? Or 100% certainty?
Yes.
Certain, as a juror sitting here, you weren't there, right?
Right.
Nobody has knowledge of the area or what happened, right? But to be 100% certain, wouldn't you have to be there at the time, do you think? Because you're relying on what these people say. You don't know them. I mean, I should read the witness list. Does anybody know Officer Margaret Adams of the Anytown Police Department? Officer Charles Barrett? No? TSU agent Thomas Cook. The Michigan State Police FSD agent Kathy Doyle. And then there's civilian witnesses, Miss Natasha Ertazzini, Mr. Robert Franklin, and Mr. Frederick Gleason. Does anybody know me personally? Okay. Anybody know Mr. Steffen, the defense attorney? And does anybody know Mr. Pitcher? Okay. So not knowing any of these people on the stand here, can you ever be 100% sure that you would stake your life on it? So nobody can be 100% sure, right? Ever. So there can be some doubt, a possible doubt, an imaginary doubt, even though that's there. If that doubt is unreasonable, case, if that doubt is unreasonable, what is your verdict now? But that doubt is unreasonable. Otherwise, you're certain that Mr. Pitcher committed the crime. If there's an unreasonable doubt.
If it's unreasonable.
There's some doubt, but it's not a reasonable doubt. What's your verdict? Sir, what's your verdict? Sir. Sir.
Thanks, Mr. Baker. Mr. Steffen?
Thank you. As the judge said, my name's John Steffen. I'm the attorney for Mr. Pitcher. First, let me thank you all for being here this morning. I know it's, well, we're getting on towards 9 o'clock, normal work hours, but I still appreciate you all being here early this morning. I just want to cover a couple of quick things to really get a feel for you, and so you can kind of get a feel for me in my case before we go forward, and let you know that if for some reason we have you disqualified as a juror, it's not a personal thing, but everyone walks into everything with some degree of bias. Is that something you agree with? What we have to determine is if that bias is going to be able to affect your ability to clearly look at the evidence, clearly look at the testimony, and determine whether the prosecution did their job or not. Do you all agree with that? All right. Now, as Mr. Baker said earlier, it's his job to prove these things happened to that Mr. Pitcher did what they're accusing him of. Do any of you know what my job is? Anyone? Go ahead.
Prove that he didn't do it?
That's the general conception. My job is actually to make him do his job. As it stands right now, as Mr. Baker said, Mr. Pitcher is completely innocent of anything that they've even thought of accusing him of. My job is to make him put on his evidence. Do you all understand that I don't have to call a single witness? You understand that Mr. Pitcher does not have to take the stand. But if Mr. Pitcher doesn't take the stand, are you going to hold that against him? You look a little hesitant there. Is that something you would consider in trying to determine if he's guilty of the crimes he's accused of?
Possibly.
Okay. And that's fair and that's reasonable. That's why we're having this discussion, to try and get a feel for these things. Now, the judge will instruct you that you're not supposed to take that into evidence. But let's be honest, some things that you're instructed not to consider, once the bell's rung, it can't be unrung. If you hear it, it's going to be stuck in your head. If he tells you to ignore certain testimony, even after you've heard it, to ignore it, do you think you'll be able to put that out of your head? I understand not completely, but when you sit down to look at the facts, will you be able to set that aside? Okay. Now, Mr. Baker also asked you if you think you can tell when someone's lying. And you all said yes. I believe one of you had stated, well, you know, their eyes shift up and down. They don't look someone in the eyes when they're answering. The voice might change a little bit. Aren't those descriptions very similar to a person who's just nervous? Will you be able to tell the difference between someone who's nervous and someone who's lying? I know it's a big question. It's something I want you to keep in mind the whole way through. Are they lying? Or are they inexperienced at being on the witness stand and just a little shaky? At this point, if the judge comes back right now and says, how do you find Mr. Pitcher? What's your answer?
Wouldn't know at the time.
He hasn't put on any evidence.
I guess not guilty.
He's, as I say, it's his job to prove the case. He's not put a single thing on. So what's your answer?
Not guilty.
Yours? An hour and a half from now, 2 hours from now, hopefully not that long, but however long it takes, when the judge comes back and says, what's your answer? If he hasn't done his job, what's your answer going to be? Same for all of you? Okay. Thank you very much.
Any challenges for cause?
Your Honor, I'm going to go for cause on number 2, front center.
Okay, sir, I don't know your name, but you can step down. Thanks for your participation. Don't leave yet, though. Just sit in the jury box, so you may be picked for a different jury.
And then, Your Honor, I would go for cause on 3 and 6 due to their previously being the victims of theft crimes.
Well, hang on a second. Do you have any objection?
I do, Your Honor. Although they've been victims of theft, I'm sure many people in jury tenure have, and I think it's quite clear that the jurors testified that they can be fair and impartial to Mr. Pitcher today, so I would object to their removal for cause.
Okay, so you two folks, you've both been victims of a similar crime. Does that mean that Mr. Pitcher's gonna pay for those 2 guys that never got caught? Can you be fair and impartial to Mr. Pitcher? If you were seated where Mr. Pitcher's seated right now, would you want you as a juror? No, sir? Okay, you can stay, you gotta go. All right. Okay, those are for cause?
That's all for cause, Your Honor.
Okay, any for cause, Mr. Baker?
None from the people, Your Honor.
Okay, any peremptory challenges,
No preemptories at this time, Your Honor.
Mr. Baker?
People would like to thank and excuse juror number 5, Your Honor.
Which one is that?
Middle of the back.
Middle of the back. Okay, juror number 5, you can be excused. All right, now, let's take, from this side of the room this time, the first 5 people, so that's you 4 in the front row, and then, come on up.
Your Honor, don't we only need 3 jurors?
Oh, you're right, we'll need the 3. I'm sorry, you first 3, come on up. Yeah, we're not replacing all of them. I keep getting confused, but they're all gonna be jurors at some point. Okay, the new jurors, welcome to the jury panel here. Were the 3 of you able to hear all the questions Mr. Baker asked of your predecessors? Yes, and all the questions that Mr. Stefan asked? Did any of those questions ring any bells or raise any flags or anything you think they may want to know? Okay. And how would that influence your ability to be fair and impartial here? Okay. Are you going to hold Mr. Pitcher accountable for whoever it was that stole your stereo? If you were seated where Mr. Pitcher's seated, would you want you as a juror? Probably not? Okay, then I'm going to excuse you. Go ahead. All right. Come on up. Okay, were you able to hear all the questions everyone asked?
Yes, sir.
Anything ring any bells with you?
No, sir.
If you were seated with Mr. Pitcher seated, could you be a fair and impartial juror?
Yes, sir.
You would want you as a juror?
Yes, sir.
Okay. Any questions you have of the new jurors, Mr. Baker?
I've read the information that the jurors have provided beforehand, Your Honor. I have no questions for these jurors.
Okay, how about you, Mr. Stefan?
Your Honor, we're satisfied with this jury.
Okay, then this will be the jury that will hear this case. What you're gonna need to do is we're gonna recruit Professor Durrell, if he's still in the courtroom. Is he here? You're gonna be the bailiff. Because we forgot to get. If you wouldn't mind escorting these jurors into the jury room there, so we can take care of any matters that might need to be addressed. All right, I'll rise for the jury, please. Okay, now at this stage, since the jury's out of the room, they don't know what's going on, and sometimes there's pretrial motions that come up the attorneys want to solve or resolve before the hearing of the jury, or without the hearing, outside the hearing of the jury. sometimes there isn't. I suspect in this case there probably is gonna be at least one, maybe two, correct?
Yes, Your Honor, we have one.
Okay, what is your motion?
Your Honor, we have a motion to exclude any evidence of the boots obtained from my client, Mr. Pitcher's home, as those were obtained outside of a search warrant. They were not obtained in any sort of a sudden emergency type situation. The officer asked Mr. Pitcher's boss if he had a way to get into the home. The boss had a key for emergency use only, was not an overnight guest, did not have authorization to go into the home, did not have the authorization to let the officer go in. Frankly, the boots are fruit of a poisonous search, Your Honor.
Okay, any response?
Your Honor, the officer didn't know that it was for emergency purposes only. The officer at the time was simply trying to find evidence. The person had a key. The whole idea is whether or not Mr. Pitcher had a reasonable expectation of privacy in his home when he gives a key to another person. And the officer at the time thought that this person had authority to let him into the house. The boots were right there out in the open inside the house. Yes, there was no search warrant, but he thought that the person that was giving him permission actually had the authority to do so. And it wasn't the officer's fault that there's this potential Fourth Amendment violation. So I'd ask that the court does not exclude that evidence.
Any response?
Yes, Your Honor. I'll respond first to the reasonable expectation of privacy. Your Honor, my mother has a spare key to my home, and I do not want her showing up without some warning, as I'm sure you would be in the same circumstance. In addition, there's no time constraint. This alleged incident happened on the 11th. They went to the home on April 23rd, 12 days later. The officer could have spoken to someone to find out that they had time. There was no press, there was no rush. There is no reason these boots should come in, Your Honor.
Okay, well, I think that when someone gives a key to somebody else, obviously they're giving them authority to enter the house, although I don't think that that authority is unconditional. You know, we haven't heard testimony from the officer or from Mr. Pitcher, obviously, but, you know, my neighbor has a key to my house too, but that's in case, you know, the water heater or the furnace goes off and my pipes freeze or the house is on fire or something like that. I don't think I want him just letting police in there or anybody in there. Besides, Mr. Pitcher didn't go inside the house. He let an officer go in. So I really don't think that the reason he gave the key to his boss was to just let anyone in, especially not 23 days later, and especially not when there's nothing wrong with the house. So we're going to suppress the boots. They won't come in. If you have any other evidence that might help you with the boots, Mr. Baker, then we'll consider that at the right time. Any other motions?
Yes, Your Honor, the people have a motion as well. There is some information in the file about Simon Van Hert's criminal history. Simon Van Hertz is unavailable, as far as I know, Your Honor, to testify today. And his criminal history is extensive. And it's my understanding that the defense is going to use that as their alibi, that this is the person who did it. This unknown person who's not going to be in the courtroom today has this extensive criminal history. That's the person who must have done it. That criminal history, Your Honor, is extremely prejudicial, and there's very little, if any, probative value to that evidence. And I would ask the court to exclude that evidence based on that.
Okay, any response?
Yes, Your Honor. As defense, we are entitled to our alibi. Further than that, Your Honor, the prosecution didn't call Mr. Van Hertz. As the jurors will hear throughout testimony, the police never even bothered to interview Mr. Van Hertz. At a minimum, if they didn't do their job, we should be allowed to bring that evidence in for the jury to consider if they didn't do it when they were going out to get a warrant against Mr. Pitcher.
If I may just respond one moment, Your Honor. In order for anything to be admissible in this case, it has to be relevant. And the defense hasn't cited a court rule for which they intend to introduce this evidence under. And that's because there isn't one. So therefore, unless there's a court rule that allows this evidence to come into court for the jury to consider, then I think the court should exclude that evidence.
Okay,
Your Honor, the court rules are exclusive. What cannot come in without an exception. Self-defense is not a court rule. There is no court rule you can cite to say this is self-defense. That alone should not preclude Mr. Pitcher from being able to use an alibi defense just because it's not merely in the court rules.
Okay, well, there's a couple issues. First, my understanding is that, from our process server, is that Mr. Van Hurst kind of flew the coop, so to speak, before anyone had a chance to get a hold of him. And as far as I know, all efforts to contact him by our process server have been unsuccessful. So I don't know that we can blame the prosecution for that. Secondly, it's kind of a weird problem, because normally criminal histories are always sought to be brought in against either the defendant, and then we get into the whole 404B argument, or they're trying to use them against a witness to impeach him or her or their testimony, and we argue about that. But in this case, it's being sought to be brought in to talk about someone's character who's not even a witness. So the person who would have standing to challenge the criminal history being used to sort of sully their character isn't here to object to it, and presumably doesn't care, because he's not here, number one. Number two, any evidence that's relevant is generally admissible. Certainly would be relevant, I think, that if there's another potential suspect who had the means and the opportunity and the motive and everything else to commit this crime, if he or she had a criminal history that was consistent with that, you could certainly say it's relevant. Now, is it admissible? I don't know, because is it more prejudicial than probative? From the prosecutor's perspective, all evidence is prejudicial, otherwise it would be worthless, and it wouldn't, in that case, it would be inadmissible because it wouldn't even be relevant. I think probably what we can do is split the baby down the middle, and what I will do is allow Mr. Baker to stipulate that Mr. Van Hurst has a criminal history, including theft, but without getting into the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 different theft crimes he has. Some of those go back to 2005, and I think maybe that would be more prejudicial than probative, especially since there's no way to rebut or figure out if any of these crimes shared anything in common with this crime, so it wouldn't even really be 404B evidence that they were trying to use it against Mr. Pitcher. We don't know that it would be. There's a 2010 home invasion, which is identical to what this crime is, but again, we don't know the exact circumstances, that we don't know if it's within the course of an employment or what. So we'll just generally allow testimony that he has a criminal history, including a conviction for theft. Okay?
Your Honor, will that include the conviction for home invasion?
Well, you know, that one is recent. It's this year, and it's the same exact crime. I guess we can let the jurors know, if it comes up, if it's otherwise admissible, that Mr. Van Hurst has a prior conviction for home invasion. We won't say what degree or anything else. We'll just leave it at that.
Thank you, Your Honor. One final note, Your Honor. The prosecution and I had discussed previously, and I believe Mr. Baker is going to stipulate to this, as we did not have full jury instructions on this case, we will be proceeding under a jury instruction similar to the common law burglary. Entered into a dwelling place of another in the night with the intent to commit a crime therein.
Okay, as opposed to the standard?
As opposed to the standard home invasion instruction, Your Honor, yes.
Okay, then maybe you guys can agree on what you want me to read and just jot it down, so I'll just read it verbatim, whatever you guys agree. But
Your Honor, I think that was it. Entered the dwelling place of another in the night
someone write
with the
down.
intent to commit a crime therein.
All right, well, maybe Mr.
We
Baker
can provide
yeah,
handwritten
we're not gonna
one
need that
for
till
you.
the end, so. Okay, any other issues now that that's resolved?
No, nothing further from the people, Your Honor.
All right, thanks. Okay, we're gonna bring the jury in, but before we do, okay, you just saw 2 pretrial motions be resolved. Some trials have 1 or none, some have 2 or 3. The purpose of that first one we did, though, with the boots, though, is to illustrate how fast a case can go south on you guys if there's a fruit of the poisonous tree issue or something like that. You know, I even had my little exhibit of the boots all ready to go to see if one of these 2 gentlemen could sway me otherwise, but these boots, which you would have found out would have matched a muddy boot print, aren't coming in now, and that's not gonna be good for Mr. Baker, but, okay, we'll see how things shake out. Moral of the story is, though, don't search illegally. All right.
Your Honor, before we bring them in, I would move to voir dire or to
Sequester the witnesses?
sequester the witnesses.
Okay, anyone who's gonna be a witness in this case, though, except for you, Elise, you can stay. Go have a seat out in the lobby. You can Elise stays here.
When do you
And
plan
I
on
have
calling
my
them?
investigating officer, Your Honor, if I may.
Yeah.
Yeah, that, obviously, we have no objection to that. And as soon as they're done testifying, we have no objection to them remaining in the courtroom.
Okay, all right, then have a seat. Okay, want to bring in the jury? All rise for the jury, please. All right, everyone but the jurors have a seat. You guys remain standing. Okay, raise your right hands. Here's your oath. Each of you do solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and you will render your verdict only on the evidence introduced in accordance with the instructions of the court. Yes? Okay, thanks. Put your hands down, have a seat. Now we'll explain some of the legal principles you will need to know and the procedure we will follow during this trial. A person accused of a crime is presumed to be innocent. This means that you must start with a presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutors may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has a right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all his evidence, the defendant's attorney may also offer evidence, but he doesn't have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witness, the prosecutor has a right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it becomes time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. It's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it might help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how a witness testifies? In general, does the witness appear to have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks a question that assumes or suggests that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask a question, my only reason would be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My ruling for or against one side or the other are not meant to reflect my opinion about the facts of this case. Sometimes the attorneys and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not discuss it with the other jurors until the time comes for you to decide the case. When it becomes time for you to decide the case, I will send you to the jury room. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, of course, discuss the case with anyone, but you don't have to. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the end of the trial, I will give you detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taken together, they are the law that you must follow. After all the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It's important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. Okay, those are the preliminary instructions you guys will get. You ready for your opening, Mr. Baker?
I am, Your Honor.
Okay, why don't you go ahead?
Ladies and gentlemen, at the end of the day, you're going to hear, after you hear the evidence in this case, it's going to show clearly, beyond any reasonable doubt, that Mr. Pitcher is guilty of the crimes he's alleged to have committed. The evidence is going to show that on April 12th of 2010, that Mr. Pitcher did either receive and conceal stolen property, or that he broke into somebody's home, Mr. Ertazini, or Ms. Ertazini's home, while she was on vacation. The evidence you're going to hear is going to be from police officers. The evidence will show that a neighbor called the police because they knew that Ms. Ertazini was on vacation. They heard a breaking noise and saw a flashlight in Ms. Ertazini's home. Thankfully, Ms. Ertazini wasn't there at the time. What was there was her property. She had an iPod Touch that's valued at about $350 that was stolen, and she had money in cash on her counter, kitchen counter, that was taken. Why is Mr. Pitcher here today? Because Mr. Pitcher was in her house the day before installing cable. He knew where this property was. He knew right where it was. And he knew that she was leaving. That's why Mr. Pitcher's here today. Also, why Mr. Pitcher is here is because he pawned the iPod. You'll hear evidence that he paid $75. $75 for a $350 iPod Touch. The value of these things is widely known. You'll hear testimony from the pawn shop owner who will tell you that is a bargain. Somebody must know this thing is hot. And that's exactly what he's charged with, buying something that he knows is hot. Stolen. He bought it from his friend, who also, the testimony might come out that he bought it from his friend who was also in the house. So one way or another, if I want to prove to you that the defendant is guilty of receiving and concealing, I don't have to prove that he stole it. But the evidence will show that he did. The broken glass, you'll hear evidence from DNA experts, will tell you that Mr. Pitcher's glove was found at the crime scene with DNA in it, linking him to the crime scene. And there'll be a broken window. What does that tell you? The judge will give you an instruction about circumstantial evidence. What that means. You can rely on circumstantial evidence. There's a lot in the media about circumstantial cases. Oh, your case is circumstantial. That's fine. Circumstances do prove crimes. You don't have to have an eyewitness every single time. In murder cases, the victim can't testify to what happened to them. It's circumstantial evidence that convicts them. It happens every day. And I'm going to ask you to do that today. When you hear all the evidence in this case, at the end of the day, I'm going to ask you, on behalf of the people of the state of Michigan, to find Mr. Pitcher guilty of the crimes. Thank you.
All right, thank you, Mr. Baker. Mr. Stephen, now or after the...
We'll proceed now, Your Honor. Thank you. Ladies and gentlemen, thank you for being with us again today. Let me just first start by getting this out in the air so we all know where we're proceeding from. Mr. Pitcher is not guilty. At the end of the day, you're going to believe that as much as I do. You're going to come to understand that the prosecution, for all their circumstantial evidence, doesn't have the case. They say the value of the iPod is $350. Maybe. You can buy an iPod anywhere from $50 to $500, brand new. We don't know where they got that figure. We don't know if this was a $200 iPod that $75 seems reasonable for a used iPod. That's about half off. Maybe it was a $100 one and he got ripped off paying $75 for it. That's something you're going to have to consider as we go forward. They're going to tell you, in Mr. Baker's own words just a moment ago, that there was DNA evidence in a glove and a broken window. But they already admit my client had been there the day before. You've got to really believe that someone is a complete fool to wear gloves, to break into a window to a home, and then leave the glove behind? Now, in the alternative, Mr. Pitcher works for a cable installation company. The company issues identical gloves, boots, work uniforms to all of their employees. He was there just a day or two before. Yeah, he left a glove behind. It's happened to all of us. We drop stuff. Would you want to be convicted on something like that? Finally, the prosecution isn't even sure of its own case to the point where they're not going forward on one theory. They're saying, well, we think he broke in. But just in case he didn't break in, we also want to say that you should get him for receiving and concealing, because if he didn't break in, well, by golly, he should have known this was stolen when he bought it. A coworker comes up and offers you something, and you're supposed to automatically assume it's stolen because you get a good deal on it? Ladies and gentlemen, at the end of the day, prosecution's not going to have their case. At the end of the day, even if you kind of believe their case, it's not going to rise to the standard of beyond a reasonable doubt. When this is said and done, I'm going to ask you to find Mr. Pitcher not guilty. And I think you'll do it easily.
All right, thanks, Mr. Stephan. You ready to call your first witness?
Thank you, Your Honor. The people call Officer Margaret Adams.
Okay, Officer Adams, get in that chair over there behind Mr. Baker. And before you have a seat, raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, have a seat, put your hand down, and spell your first and last name, please.
M-A-R-G-A-R-E-T-A-D-A-M-S.
Okay, thanks. Okay, Mr. Baker.
Thank you, Your Honor. Officer Adams, thank you for being here today. Clearly, we can tell by your uniform you're a police officer, and we call you Officer Adams, right? How long have you been doing that?
I've been a police officer with Anytown Police Department for 10 years.
Okay, 10 years. In those 10 years, have you had occasion to respond to burglaries, robberies,
Yes.
those sorts of things?
I've responded to many, probably 40 or 50.
Okay, very good. Were you working as a police officer for Anytown Police Department on April 12th, 2010?
Yes, I was.
And did you have occasion to respond to 1313 Mockingbird Lane in Anytown?
Yes.
Why did you go there?
We got a 911 call stating that the neighbor had heard windows breaking at the house next door, and they knew that the resident was on vacation. They saw a flashlight inside. They thought someone was breaking in.
And so you arrived there. Was this at nighttime?
Yes, it was 1:30 in the morning.
Okay. What did you do when you got there?
My partner and I, Officer Barrett, he went around to the back, and I tried the front door. The front door was locked. He made entry in the back. I went around to the side and saw a window that had broken glass right next to the doorknob, and I could tell that it was freshly broken. The rest of the window was dusty, and the edges of the broken glass were clean. So I could tell that it had been done just then, and that door was unlocked.
Did you get information from the caller that they heard a breaking sound?
Yes, sir.
Okay. And you suspected that broken window, somebody was in the house?
Yes.
Okay. Showing the defense what's been marked for identification as People's Exhibit Number 2. May approach the witness, Your Honor.
Sure.
Handing you what's been marked as People's Exhibit Number 2 for identification. What is that?
This is the broken door that I saw on the side of the house.
Objection, Your Honor, foundation.
Okay, you wanna,
We're working on the foundation, Your Honor.
okay, well, let's get no questions out and see.
Unless the court needs a foundation for my foundation.
No, Your Honor, just she went straight to the substance of the photo.
Right.
Okay. That picture purports to be the window that you just described as being broken, right?
Yes.
Okay. And looking at that picture, is that picture a fair and accurate representation of what that window looked like to you at the time?
Yes.
Okay. Your Honor, move for the admission of People's Number 2.
No objection, Your Honor.
Okay, hit exhibit number 2.
Thank you, Your Honor. May have published to the jury.
Sure.
Did you eventually enter the house, officer?
Yes.
Okay. What happened when you did that?
I entered the house, and someone ran by me very quickly. It was really dark. I could hardly see him, but he went out, or I ordered him to stop. I told him I was the police, and he went out the back door.
This was a male then?
Yes.
Could you describe the person that you saw run by?
I'm not sure what ethnicity he was. He was wearing dark cargo pants, a black and blue hoodie, and a stocking cap.
Okay. And the house was dark?
Yes.
And you testified he ran past you out the back door?
Yes.
Okay. What happened after that?
I heard my partner, who was in the back of the house, tell him to stop several times. I followed them out the back, and he was in a foot pursuit, and I heard him calling out for backup. I went to my cruiser that was parked out front and went around back to try to cut him off, but wasn't able to locate him.
And your partner, that's Officer Charles Barrett?
Yes.
Okay. And you weren't able to locate the suspect at the time?
No, sir.
Okay. Did you collect any evidence at the scene?
Yes, we did. After the pursuit, we went back to the house. We took the glass in for evidence, and also we found a glove next to the door.
Was that in the northeast corner of the living room?
Yes.
Okay. Okay. So, at this time, as far as you're concerned, this case is wide open. You don't know who it is. Okay. What did you do? Did you leave your card or?
Yes, yep, I left my card on the counter, informing the resident to contact me when she returned home from vacation, so I could further investigate.
And the resident, that's Natasha Ertazzini?
Yes.
Okay. Did you eventually have contact with Ms. Ertazzini?
Yes.
Okay.
She returned home on the 14th, I believe. I talked to her, and she confirmed that she had an iPod on the top of her TV and some money on the counter that was taken.
Okay. So when she was on vacation, you said?
Yes.
And when she left, that stuff was there,
Yes.
and now it's gone.
Objection hearsay, Your Honor.
Which part?
Well, the officer is just testifying to what she was told. She has no firsthand knowledge over whether this stuff was at the home or not. And if Mr. Baker wants, he can call Ms. Aratazzini to testify to what was in her home and what was not.
Okay, and I suspect he will be calling her, she'll probably be upset that she had to get up so early to come here this morning. Any response?
That's true, Your Honor. At this point, the people aren't offering this evidence for its truth, just as a documentation of what the officer did at the time.
Okay, so it's not being used to prove the matter asserted that the iPod was on top of the TV, you're only using it to prove what, to explain
The
why?
officer's knowledge to explain why, and we're gonna get to what she did after that as part of her investigation, just to give light to that.
Okay, well, for that purpose, we'll allow it.
Thank you, Your Honor.
Okay, go ahead.
So you suspected that these things were taken
Yes.
based on what Ms. Artazzini told you?
Yes.
And did you eventually wind up at a pawn shop?
Yes.
Okay. What happened there?
I was contacted by TSU. They said that an iPod had been sold to the pawn shop, and it matched the serial number that Miss Erdzini gave me that went with her iPod.
Okay. So you had the serial number match.
Yes.
So you can say definitively then that the iPod that you found at the pawn shop was the iPod that came from Ms. Erdzini's home.
Yes.
And presumably that was the night it was broken into, that was taken.
Yes.
Objection calls for speculation.
Yeah, and I
It's
guess
a little late.
we're not supposed to presume anything, so.
That's fair, Your Honor.
Okay,
I'll
Your Honor, I'd at least like an instruction for the jury to disregard.
Yeah, disregard that, you know, you're not gonna presume anything, you're gonna go back to the jury room with the facts and evidence you hear at trial and then make up your own. Don't presume something just because Mr. Baker tells you to or Mr. Stephan tells you to. Okay, go ahead.
Thank you, Your Honor. In any event, the serial number matched the iPod that Ms. Ertazzini reported as stolen.
Yes, it did.
Okay. Do we know who pawned this iPod?
Yes, it was. May I refer to my report, please?
Yes.
Yeah.
Your Honor, I may as well preemptively object again on hearsay. If he wants to call the owner in to testify as to who pawned the item to him, that's one thing, but again, Officer Adams is not gonna have direct personal knowledge of this.
No, but I think again, it might, you know, what she learned or didn't learn may be true, might be false, but it will at least explain why she proceeded the way she did after she learned this information, whether it's true or false. I don't know that you're offering for the truth of it.
I don't know that it's hearsay, or I don't know that's an assertion by anybody. She simply reviewed business records to see who pawned an item. That's where I'm going with this, Your Honor. I don't know that's as an assertion of any kind that would invoke any type of hearsay argument.
Your Honor, I would find it interesting that the prosecution cites a hearsay exception in claiming this is not hearsay.
We'll allow her to review her report. It refreshes her memory. We'll see. But I think for the purposes of explaining what steps she took in subsequent investigation, it can come in. And not necessarily for the truth of the matter asserted, could bring it from other witnesses. For that, it might be better. Okay, why don't you go ahead?
Were you able to determine throughout your investigation, officer, who pawned that iPod?
Yeah. Yes, sir. Mr. Pitcher pawned the iPod.
How do you know that?
Because the pawn shop owner took driver's license copy and a thumbprint from the person who sold the iPod to him.
Okay. And that's something that he's obligated to do by law, right?
Yes, sir.
To keep these business records.
Yes.
And in fact, you routinely go and review these records.
Yes.
And that's what you're doing in this occasion?
Yes.
Okay. And that's how you glean that information?
Yes.
Did you have occasion to speak to the defendant?
Yes,
Mr.
I
Fisher?
did. Yes, I did. I went to his home on April 22, and I asked him if he had been in the home, and he said that he and his partner, who worked for Century Cable, were in the home, and he didn't know that the iPod was in the home, but that Van Hurst sold him. Van Hurst is his partner at Century Cable, sold him the iPod later for $75.
Did he say why he bought it at all? Do you recall?
Van Hurst told him that he had just gotten a new iPod and that he didn't need to, so he sold it to him for cheap.
Okay. Did Mr. Pitcher buy it for his own personal use, or did he make an assertion to you in that regard?
No, he told me,
Again, Your Honor, that calls for speculation.
I mean, unless she, well, I guess the better way of asking it is, did Mr. Pitcher tell you why he bought it?
yes, he did.
Okay, maybe that's a better way.
Thank you.
But-
Your Honor.
Mr. Pitcher told me that he knew the iPod was worth more, so he brought it to a pawn shop so he could flip it, is what he told me.
Okay. Did you collect any DNA from Mr. Pitcher?
Yes.
Okay, how'd you do that?
Did you ask for consent?
Yes, I did.
And did he give you consent?
Yes, I got a DNA sample from him.
The swab?
A swab, yes.
Okay.
And the way you took that DNA sample, is that consistent? Are you trained on how to take DNA samples?
Yes, sir.
And the way that you took that DNA sample, was that consistent with your training and experience?
Yes, it was.
Thank you. That's all I have.
All right, thanks, Baker. Mr. Stefan?
Thank you, Your Honor. Hi, Officer Adams. How are you doing today?
I'm good, how are you?
Doing well. Just have a couple of quick questions about your testimony. One or two things I want to ask. And again, let me apologize for interrupting Mr. Baker while he was questioning you so much. When you were at the home, you testified that you couldn't get a good look at the man who ran past you?
Yes, sir.
Couldn't even tell ethnicity?
No, sir, it was very dark, it was very fast. It surprised me.
Okay. You had a chance to talk to my client,
Yes, sir.
and you talked about, through your testimony to Mr. Baker, some of the things he told you regarding where he got the iPod, that sort of thing. Did you have any reason to doubt him on that?
No, sir.
Did you ask him specifically if he took it? Or if he knew it was stolen?
No, sir.
Your Honor, may I approach?
Sure.
Ms. Adams, I'd like to point to your police report, specifically this line. Let me ask again. Did you ask him if he knew it was stolen?
Yes, I suppose I did.
And did he deny knowing it was stolen?
Yes, he did.
Okay. Thank you, Ms. Adams. You're aware that he had a partner?
Yes.
Did you speak to that partner?
No, I did not.
Did you run a criminal history on that partner?
Yes, I did.
And without getting into specifics, was that history extensive?
Yes.
Your Honor, I just at this time, it's not really an objection, just clarification to prevent an objection. I think that we've stipulated that the person that defense counsel is talking about, Simon Van Hertz, does have a criminal history for theft. We've stipulated to that, and I don't know if we want to go any farther.
Yeah, I think specifically what we talked about is the parties have agreed, without wasting time with going through the rigmarole of all these documents and certified things from other courts, that this Mr. Van Hurst we're talking about does have a prior conviction for a home invasion. So you could accept that as a fact, but move on from there. All right, thanks.
Thank you, Your Honor.
Thank you, Your Honor. And for clarification, we are allowed to mention the year that home invasion came in?
Sure. That was 2010.
Thank you. So we can have it from the witness. You heard, was there a home invasion?
Yes, there was.
And what year was that from?
2010.
Thank you very much. Nothing further, Your Honor.
Okay, any redirects?
Briefly, Your Honor. Also, you've been a police officer for 10 years, right?
Yes, sir.
You've had occasion to interview several people who've been charged and convicted of crimes, right?
Yes.
Do they all admit to you what they did when you ask them?
No,
How often does that even happen?
not very often.
Thank you.
All right, thanks. Mr. Stefan, any questions?
Nothing further, Your Honor.
All right, you may step down, Officer Adams, and join Mr. Baker back over here. Who's your next witness?
People call Officer Charles Barrett, Your Honor.
Charles Barrett. Is the bailiff awake? Any,
I'll go get him.
you need him? Okay. Couldn't see mine.
Officer Charles Barrett? Go on, go right up to the witness stand.
Okay, Officer Barrett, if you don't mind, go to the witness stand over to my left, get behind the microphone and raise your right hand before you sit down. You swear the testimony you give me the truth, the whole truth, and nothing but the truth?
I do.
Okay, thanks. Have a seat and tell us and spell your first and last name.
First name is Charles, Charles. Last name is Barrett, Barrett.
All right, thanks very much. Okay, Mr. Baker.
Thank you, Your Honor. Officer Barrett.
Yes, sir.
Again, we call you Officer Barrett because you're a police officer, right?
Yes, sir.
And you're in uniform, correct?
Yes, sir.
Okay. How long have you been a police officer?
About 3 years.
And where do you work?
Anytown Police Department.
Okay. Were you working at, what are your duties as a police officer for any town?
For Anytown, I'm on road patrol. I'm responding to calls.
Calls for service?
Calls for service, yes.
Okay. And you were doing that on April 12th, 2010?
Yes, sir.
Anything out of the ordinary happen around 1:30 in the morning?
We were called from, or dispatched for a 911 call for a possible home invasion or burglary.
Was it at 1313 Mockingbird Lane?
Yes, sir.
And that's in any town?
Yes, sir.
Okay.
It was me. I was partnered with Officer Adams.
Okay. Just to paint the picture, as you were responding to the scene, what information did you have from 911 dispatch?
Just that neighbor noticed, I believe, somebody that was in the house, and they believe that they were still in the house at that time.
Okay. And what did you do then?
We responded to the address, 1313 Mockingbird Lane. Pulled up the scene. Lights were out in the house. It appeared dark, unoccupied. Officer Adams went to the front of the house. I went to the rear of the house, set up a perimeter. Officer Adams announced that we were there, and soon after she announced, the suspect bolted out the back of the house, and I gave chase. We went through a few backyards, jumping over fences. I eventually lost him in an alleyway. Officer Adams tried to locate the suspect in her cruiser. We could not. I returned to the scene and called for forensics to come out. There were footprints over at the back door area. I believe only one of the footprints was usable.
Okay. Did you get a good look at the person who ran out the door?
What I saw was an unknown male. He was about 6 foot tall, wearing dark colored cargo pants and a black or dark hoodie.
Okay. But you couldn't tell who it was?
I could not.
If you saw him today, you wouldn't know based on that?
No, sir.
Okay. Did you locate any evidence in this case, physical evidence?
On on, was it April 23rd? I located a glove and a van. And that was it. That was at the cable company. Mr. Franklin gave me access to a van.
Okay. Did you turn that over to anyone for processing?
I turned it over to field services or
Okay.
technical. Yes.
Thank you very much.
You're welcome.
Okay, Mr. Stephen, any questions of this officer?
I do, Your Honor. Just getting a few quick ones. How are you doing today, officer?
Good. How you doing, sir?
Doing well, doing well. You testified you didn't really get a good look at the suspect, just he was approximately 6 foot tall.
Correct.
Couldn't tell ethnicity.
No, sir.
Okay. You testified you found a boot print.
Yes.
Now, and forgive me for asking this way, when you were running after the suspect, did you stop and mark it when you were running, or did you find it when you came back?
When we returned to the scene, we found it.
So it's possible that boot print was there previously?
It's possible.
You know what size boot print that was?
I do not recall, sir.
Did it appear average foot size?
Bag average. Yes.
Could have been anyone's print?
Yes, sir.
You know how long the print had been there?
No, I do not.
Thank you, officer.
You're welcome.
Okay, thanks, Mr. Stephen. Any other questions?
Yes, Your Honor, this isn't really a redirect. I have an exhibit that I'd like to propose instead of recalling the witness later.
Your Honor, we have no objection to the boot print. Oh, that's not the boot print. Go ahead.
I'm showing for the record, Your Honor, defense counsel, what's marked as People's Exhibit number 4.
Okay, those are the gloves?
May I have one moment, Your Honor?
Okay, any objection?
Your Honor, obviously, we're going to have to wait for foundation. Opposing counsel and I were conferring, based on the nature of this case, as to how to proceed on certain items.
Okay, and I should probably mention to both of you that in my quick search for exhibits, that's the closest I come to leather, so that's leather. Okay.
We'll pretend for the case,
All
Your
right.
Honor.
Okay.
I'm gonna do 4 first. I've shown defense counsel, for the record, Your Honor, we're looking at exhibits 1, People's Exhibits, proposed exhibits 1 and 4. I'll begin with number 4. I may approach the witness, Your Honor.
Sure.
Officer, I'm handing you what's been marked as People's Exhibit, proposed exhibit number 4. What is that?
Pair of gloves, sir.
Leather gloves?
Yes.
Are those the gloves, or one of those gloves, the gloves that you recovered?
Yes, sir.
Okay. How do you know that?
It's the glove that we took a photograph of the glove.
Somebody took a photograph, and that's what you're looking at?
Forensics came, took a photograph of the glove, collected it at the scene.
And that's a fair and accurate representation of that glove?
Yes, sir.
Okay. People move for admission of People's 4, Your Honor.
Any objection, Mr. Stephen?
No objection, Your Honor.
Okay, we'll admit that is Exhibit 4.
I'll take people's number 4 from you and hand you what's been marked as people's exhibit number 1. You've seen that.
Your Honor, we'll stipulate to the entry of Exhibit 1.
Okay, and what is that, officer?
It's a muddy footprint, sir.
Okay, is that
The boot
footprint you took a picture of, or that someone took a picture of?
that I found and forensics took a picture of.
Okay, all right, we'll admit it then.
Thank you, Your Honor. No further questions.
Okay, any further questions of this witness?
None, Your Honor.
Okay, then you may step down, officer, and you may stay in the courtroom if you want.
Yes, sir.
I've been told that Mr. Franklin, the cable company owner, has somewhere he needs to be, so why don't we take him even if it's out of order, that will work.
Thank you, Your Honor. And for the court's notification at 10:15, 10:20, I do need to step out briefly because I do have a real defendant who is supposed to be here today.
Okay, all right. Why don't we get Mr. Franklin then? And then we'll take maybe Ms. Ortizidi after that.
We should skip to change her name to Smith as well.
Yeah. Can you let
I'll go get, we're looking for the shop
Mr.
owner, Franklin.
yeah.
Okay, who's playing Mr. Franklin? All right. George, I have a favor to ask. Sure. I have a real client who's supposed to be here about 10:30. If he happens to pop his head in, could you
Was
let me
it
know? Ryan Wantland.
Wantland?
Wantland. It's scheduled for a plea. I'll poke my head out about 10:30, but just in case. We'll have him out of here within 10 minutes. That's why we called him now. Thanks, Dave. Just go right up to the stand. Stand up for a moment before you have a seat.
Okay, Mr. Franklin, before you have a seat, raise your right hand. You swear the testimony you give you the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thanks. Have a seat. And Mr. Baker.
Thank you, Your Honor. Morning, Mr. Franklin.
Morning, sir.
Understand you have somewhere to be. I'll make this brief. What do you do for a living?
I own a cable company.
Is it Century Cable?
Yes, sir.
Do you or have you in the past employed Simon Van Hertz and a Mr. Lewis Pitcher?
Yes, sir.
You see Mr. Pitcher in the courtroom today?
Yes, sir.
Can you point him out for the court?
There's,
May the record reflect identification, Your Honor.
What's he wearing?
he's wearing a gray shirt, blue jeans, white shoes.
Okay, any objection?
Your Honor, I've got to ask, it's a successful recognition of Mr. Pitcher, but I don't see how this relates to identifying Mr. Pitcher as being in the courtroom or Mr. Pitcher being accused of anything.
Well, I think just for identification. But is this Mr. Pitcher?
Yes, sir.
Okay, all right. The record will reflect.
Thank you, Your Honor. Now that we know who we're talking about, what did Mr. Pitcher do for you?
He installs the cable at homes for us, so the boxes, the wiring, and all that.
Did he partner with anybody regularly?
With Lewis, or sorry, Simon.
Simon Van Hertz?
Yes.
Okay. What kind of guy is Simon?
I mean, he gets the job done, but he's not reliable. He arrives late. He oftentimes either doesn't show up or he gets to work late. So.
There's been evidence that Mr. Van Hertz has some criminal history, that being a home invasion in 2010. Were you aware of that?
No, sir.
Okay. Did you eventually have contact with the police?
Yes, sir.
And they were investigating Mr. Pitcher, right?
Yes, sir.
Okay. And you gave them access to a van, is that correct?
Yes, sir. Company van.
And whose van was that, or who used that van typically?
Usually Lewis and Simon.
Okay. I'm handing you what's been admitted into evidence as People's Exhibit number 4. What is that?
Those are gloves that were retrieved from the van, sir.
Okay, so you were there while those gloves were taken from the van,
Yes, sir.
and you testified that Mr. Pitcher frequently uses that van?
Yes, sir.
Thank you, that's all I have.
apparently my criminal defendant is here, so if we can take a short recess as soon as this is done, Your Honor.
Sure.
Thank you. Mr. Pitcher, or I'm sorry, Mr. Franklin, you spoke with the police officers on the 23rd, you said?
Yes, sir.
And you identified the gloves in Exhibit 4 as being gloves that were recovered from the van?
Yes, sir.
Isn't it true that you issue every employee company gloves?
Yes, sir.
And they would all be identical gloves?
Correct.
Okay. Have you seen Mr. Ben Hurst since, I don't know, past couple of weeks?
Actually, no. Tried to make contact with him. Cell phone's disconnected. Landlord tenant saying that he no longer stays there. So where his whereabouts are, I don't know.
And have you seen Mr. Pitcher since then?
No. Actually, I seen Lewis come in and pick up his check on the 15th.
Have you fired Mr. Pitcher?
Nope.
Okay. Do you run criminal histories on your employees?
No, sir.
Okay. Think you might do that after this?
Yes, sir.
Okay, thank you, Mr. Franklin. I have nothing further, Your Honor.
Any other questions, Mr. Baker?
Nothing from the people, Your Honor.
Okay, thanks. You can be excused and go on about your business if you got somewhere to be.
Thank you.
Your Honor, I would ask for a 5-minute recess at this point.
Yeah, why don't we go ahead and take a 5-minute break, and you guys can stretch your legs in the jury room, use the bathroom, whatever you want back there. But again, don't talk about the case. Call your next witness.
Thank you, Your Honor. The people call Agent Thomas Cook.
Okay. Right up to that chair where the microphone is, and before you have a seat, raise your right hand. So the testimony you give you the truth, the whole truth, and nothing but the truth.
Yes, sir.
Okay, thanks, have a seat.
Thank you, Your Honor. Agent Cook, what is it that you do for a living?
I am a technical service unit.
What is that? What do technical service unit people do?
I lift fingerprints and other stuff, DNA, for the police department.
Gather technical evidence?
Yes, sir.
Okay. How long have you been doing that?
About 15 years.
And were you doing that on April 12th,
Yes, sir.
2010? Did you respond to 1313 Mockingbird Lane?
Yes, sir, I did.
What did you do when you got there? First of all, was this about 1:30 in the morning?
Yes, sir, it was.
Okay. What did you do when you got there?
I got there and I located some broken glass near the side door in the interior of the garage, and I took a sample of that, as well as I located a right-handed leather glove underneath the couch near the back door.
Okay, I'm going to show you what's marked as People's Exhibit, what's been admitted as People's Exhibit number 2. Is that the glass that you,
Yes, sir.
and People's Exhibit number 4, is that the glove?
Yes, sir.
Okay. Now, with regard to the glove, did you preserve that in any way for further testing?
I sent it to the Michigan State Police for further DNA testing.
When you collected the glove, are you trained on how to collect that to preserve it for DNA?
Yes, sir, I am.
Okay. And what do you do in order to do that?
I use gloves, put it in a plastic bag, seal it up.
Okay. And you did that on this occasion?
Yes, sir, I did.
Okay. And then that went to the state police?
Yes, sir.
Okay. Thank you. That's all I have.
Okay, just stop. Any questions?
Yes. Mr. Cook, what day did you testify you were at the home?
April 12th.
Okay. Turning to Exhibit 1, did you take this photograph?
Yes, sir, I did.
Could you explain why it's dated 18 days after you were in the home?
I do not remember, sir.
Camera malfunction, possibly, something
Possibly.
along those lines. Wouldn't that be something someone in the technical service unit should be aware of?
Yes, sir.
Okay. And I do understand mistakes happen to all of us, but you did send the DNA off,
Yes, sir.
followed all standard procedures for that?
Yes, sir, I did.
All right. Nothing further, Your Honor.
All right, thanks very much. Any other questions for this witness?
Nothing further, Your Honor.
Okay. Once I'm going to take a quick break for 1 second. Mr. Drell still here?
He's out in the lobby.
You might have to pinch hit as judge for a minute. I got a couple civil motions due next door. Want to keep that? You feel comfortable pinch hitting as judge for a minute?
Doesn't look hard.
I gotta, do some civil motions.
You're gonna need that.
Yeah.
A stunt robe. All right, where were we?
I had just finished with Agent Thomas Cook, I think.
I think
he was
Agent Cook
either
can be
gonna redirect.
excused at this time, yeah.
Great, thank you for your testimony.
People call Agent Kathy Doyle, Your Honor. Kathy Doyle? This will be real quick.
I'm probably supposed to swear in the witness or something. Raise your right hand. You, swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Agent Doyle, will you state your name for the record, spelling both first and last?
Agent Kathy Doyle, C-A-T-H-Y, last name D-O-Y-L-E.
Thank you. Agent Doyle, what is it that you do for a living?
I am with the forensics unit with the Michigan State Police.
Okay, and what do you do as a forensics person?
Analyze DNA.
Okay. Were you in that capacity somewhere around May 15th, 2010?
Yes, sir.
I'm going to show you what's been marked and admitted as People's Exhibit number 4. Do you recognize what's in that picture?
Yes, sir.
And what is that?
It is a glove that I analyzed DNA on.
Okay. Were you able to come to any sort of conclusion based on your analysis?
Yes, I found it conclusive to match the defendant.
And Mr. Pitcher?
Yes, sir.
Okay. How sure are you?
99.999%.
Okay. Several nines, right?
That's correct.
Okay. And your training experience as a DNA expert, is that a conclusive match?
Yes, sir.
Is it likely that that DNA could have come from anybody else?
No, sir.
Okay. Thank you. That's all I have. Thanks.
Good afternoon, Ms. Doyle.
Good afternoon.
99 point, a whole lot of nines.
Yes, sir.
There's absolutely no doubt that the DNA in that glove came from Mr. Pitcher,
That it came from or did not come from?
that it came from Mr. Pitcher.
It came from Mr. Pitcher, yes.
But do you have any knowledge whatsoever of why his DNA would end up in that glove?
No, I do not.
Would you expect DNA from a person to end up in a glove they wear to work on a daily basis?
Yes, sir.
Okay. Would you expect it to end up in a glove they wear 2 or 3 times?
Yes, sir.
And did you test for any other DNA?
No, I did not.
Okay. Thank you very much. Nothing further, Your Honor.
Nothing further from the people, Your Honor.
Yeah, you may be excused.
All right, thank you.
You can remain in the courtroom for the balance of the hearing here today, if you like.
People call Mr. Frederick Gleason, Your Honor. I can get him. Frederick Gleason? Fred Gleason? Pawn shop owner, right? All right. Come on in. Go ahead up to raise the witness stand. Told you that'd be fast.
Before you sit, will you please stand and raise your right hand? Swear and affirm the testimony you're about to give shall be the truth, the best of your information, knowledge, and belief.
Yes, sir.
So help you God.
Yes, sir.
Vaya con Dios.
Mr. Gleason, will you say your first and last name, spelling them for the record, please?
Frederick Gleason, Frederick Gleason.
Thank you, sir. What do you do for a living?
I own Crazy Freddy's Pawn Shop.
Okay. Are you Crazy Freddy?
I am.
Did a Mr. Lewis Pitcher come into your office at some point, or to your pawn shop at some point?
Yes, sir.
Do you remember when that was?
I do not.
Okay. Did you write a statement for the police?
Did I? Yes.
Okay. And if you looked at that statement, might you be able to remember telling them when that was?
Yes, sir.
Okay. Approach, Your Honor.
Please.
April 25th.
Thank you. What did Mr. Pitcher do? What business did he have with you there?
He came in, he wanted to pawn a iPod that he had got from a friend. He said he had got a good deal for it, and he thought he could make more money by selling it to me.
Okay. And I'm showing you what's been marked as People's Proposed Exhibit number 3. Do you recognize what that is?
Yes, sir.
What is that?
That's the iPod that he brought in.
That's the one that he brought in that day?
Mm-hmm.
Thank you. Is that, and that's a picture, is a fair and accurate representation of that?
Yes, sir.
Okay. Move for the admission of People's Exhibit number 3, Your Honor.
No objection, Your Honor. So admitted.
Thank you, Your Honor. How much are those iPods worth?
I'm not sure retail value.
Would be fair to say they're about $350.
Could be, yes.
Okay. Is $75 a good deal for something like that?
Yeah. Yeah, very good deal.
What were you about to say?
I was going to say it's a steal.
Thank you. Do you, as a matter of business, record the serial numbers of the things that you get?
Yeah, on our property sheet, we also have to give an ID and a thumbprint of the person that brings it in.
Okay. Did you take that from Mr. Pitcher?
Yes, sir.
Do you see Mr. Pitcher in the courtroom today?
Yes, I do.
Where is Mr. Pitcher?
Right over here.
What's he wearing?
Right now?
Yes.
Jeans and a gray shirt.
Okay. May the record reflect identification, Your Honor. Thank you, Your Honor. How much did you give him for the iPod?
It was $100, I believe.
Okay. A little less than a steal?
Just a little.
Okay. Did the police eventually come and search the records?
Yeah, we have to give our weekly property sheet, and after they reviewed it, they saw that the iPod matched a stolen one, and they came and they took the iPod and also the copy of his ID and the thumbprint.
Okay. Thank you. That's all I have.
Oh, please remain seated.
Bob,
I'd like to
jumping
turn
the
if you
gun.
don't mind, Mr. Gleason.
Trying to get out of here.
Mr. Gleason, how you doing today?
Good, how are you?
Good. Just a couple of quick questions. You say you paid $100 for the iPod,
Yes, sir.
and what do you expect to turn around and sell it for?
200, somewhere in there.
So my client made a $25 profit, roughly 30% increase over what he paid. You're going to make a $100 profit, a 100% increase over what you paid? Sounds like you're kind of in the business of getting things for cheap and selling them for more.
Yes, sir.
Do you fault anyone else if they can get that same deal?
No?
And how did my client seem when he came in?
Just a normal guy, just like any other customer.
Okay. Didn't seem nervous, didn't seem edgy,
Mm.
didn't hesitate when you asked for a thumbprint?
No?
All right, nothing further.
Nothing further for this witness, Your Honor.
You may be excused.
People call Ms. Natasha Ertazzini.
Please raise your hand. Swear or affirm the testimony you're about to give shall be the truth, your best information, knowledge, and belief?
Yes.
So help you God. Thank you.
Good morning, Ms. Ertazzini.
Good morning.
Still in the morning time. Can you state and spell your name for the record, please? You can refer to your hand if you need to.
Yes. No, N-A-T, what is it? N-A-T-A-S-H-A-E-R-O-T-Z-I-N-I, or something like that.
Thank you. Fair enough. Ms. Ertazzini, where do you live?
I don't know.
1313 Mockingbird Lane?
It doesn't say on there, sorry. Yes.
Is that fair? Okay. Did you have the cable company at your house a while back?
Yes, April 10th.
April 10th, okay. Do you see in the courtroom anybody that was one of those cable people?
Right there.
What's that person wearing?
What is he wearing right now?
Yes.
Gray shirt, jeans, shoes.
Okay. Do you know his name?
Mr. Pitch.
Okay. Mr. Pitcher?
Pitcher. Yes.
May the record reflect identification, Your Honor. Thank you. How long were they at your house?
Roughly probably 3 hours-ish.
Okay. And did they, in that time, were they just in one room or were they around the house?
They were in and out.
Okay. And that was on April 10th, you testified, right?
Yes.
Okay. Did you go on vacation at some point?
The next day I did.
Okay. When you left for vacation, eventually something came up missing, is that right?
Yes.
What came up missing?
Some money on my countertop in my kitchen, and then also my iPod that was on my television,
Okay, your iPod was on your television?
on the top of it.
Okay. And do you know, how did you know that something might have been wrong when you came home?
Well, there was a note that was left, or a card for the police department to call them.
Okay. Was anything broken?
The window was.
Okay. How much did you said your iPod was missing?
Mm-hmm.
How much did that cost?
$350.
Okay. How much money did you have on the counter?
Roughly 30 to 50.
Okay. And you eventually spoke to the police about this?
Yes.
Okay. That's all I have. Thank you.
Hi, Ms. Artazzini. How are you doing today?
Good, how are you?
Doing well. Sorry we've kept you waiting in the courtroom so long. I'm sure it was an early morning for you. Probably would
Definitely.
have preferred to have slept in.
Mm-hmm.
How did you know Mr. Pitcher's name?
I was told that.
You,
It's being in the courtroom.
okay. You weren't familiar with him other than you recognized him from
Yes.
being in the home. But you're not friends? You didn't?
Nope.
The other cable guy who was there, do you know him at all?
No.
Okay. You testified your iPod was on top of your TV.
Yes.
How long had it been there?
I don't currently know.
One of those, you set it on top and forget about it.
Exactly.
Could have been a day, could have been an hour, could have been
A week, yep.
Okay. For a new iPod, you don't use it that much.
No.
Okay. When Mr. Pitcher was in your home,
Mm-hmm.
did you get any odd feelings about him?
No, he was very nice.
Did you feel like you needed to stay and watch him the whole time?
No, I just went on my business.
Okay. And the other guy who was there with him?
Same thing, didn't notice anything really strange.
All right. And you do have your iPod back now?
Yes.
All right. Nothing further.
Nothing further for this witness, Your Honor. The people rest.
The people call Mr. Pitcher, or I'm sorry, the defense calls Mr. Pitcher, Your Honor.
Do your
Mr. Pitcher, could you state and spell your name for the record, please?
Is it Lewis? Lewis, Pitcher.
Okay, thank you. You've heard all the testimony about you today.
I did.
Were you in Mrs. Artazzini's home?
Yes.
Do you wear gloves when you work?
Mm-hmm.
Were you wearing your gloves that day?
Yes.
Did you have both of your gloves when you left?
I don't really remember. It's possible that I may have left one behind when I was working there.
Okay. What about Mr. Ben Hertz? What do you think of your partner?
You know, I actually don't know him very well. We just kind of work together. We don't really hang out outside of work. From what I hear, he's not very reliable. He shows up late to work sometimes.
He's left you waiting a few times?
Yeah. Mm-hmm.
Okay. But you're not friends?
No.
Just co-workers?
Yep.
Okay. How did the iPod come to be in your possession?
Well, he approached me while we were at work one day, and he said that he had gotten another one for his birthday. So he really had no use for this one, and he offered to sell it to me.
All right. And who came up with the $75 figure?
He just offered it for $75.
Seemed like a good deal?
Mm-hmm.
Did you think maybe you should offer him $125 just so it seems like you're paying the right amount?
No?
You didn't want to overpay?
Exactly.
Did you have any reason to believe it was stolen?
None. No, he didn't give me any reason at all.
Could you tell one iPod from another?
No, there's so many different models, I don't know.
How many homes do you work in a given week?
Probably maybe 5 a day, 25 a week.
Okay. Do you notice if the homeowners have iPods laying out?
Not necessarily, no.
All right. Really, I've just got 2 more questions for you. Did you break into Miss Aratazzini's home?
No.
And had you known the iPod was stolen, would you have bought it?
No.
I have nothing further, Your Honor.
Thank you, Mr. Baker.
Thank you, Your Honor. Sir, how long have you worked with Mr. Verhulst?
I've been partners for a couple of years.
Couple of years?
We worked together for a couple of years, yeah.
So you're aware of his home invasion in 2010 that's been spoken about today?
I am, yes.
Okay, you're aware of that. You're aware of that then also when you bought the iPod from him, right?
No, I wasn't aware of that at the time. I've
Well,
just been aware of it today.
You just tested, so when you just testified before, when I asked you, you said you were aware of that. You're saying you just found that out today?
Yeah, I thought you were asking if I was aware of it now.
You testified that you also wear gloves a lot, right? How many pairs of gloves you got in your van?
Just one pair for myself.
One pair for yourself. You heard the testimony that the glove was recovered from the crime scene on April 12th, right? And you also heard testimony that they didn't recover another glove until the 24th, yes? And with one pair of gloves, if you're missing one of them, you'd think you'd notice that, right?
Yes.
Okay, but you didn't tell anybody about that, did you? No. Okay. And that, in fact, you have no reason to deny that the DNA in that glove found at the house was yours, do you? No. That, in fact, is your glove, isn't it? By the broken window.
Your Honor, there was no testimony that the glove was found by the broken window. It was just testimony it was found in the home.
I think there just was testimony, Your Honor. He answered the question.
Your Honor, the way he words it doesn't get him to let that in.
I think the jury can, I'm allowed to lead, Your Honor, and I think the jury can take the answer as they heard it. Thank you, Your Honor. I have no further questions.
Yeah. Redirect, Your Honor, please. Do you have access to multiple sets of gloves at work?
Yes.
Do you switch out gloves in the morning sometimes?
Sometimes, yes.
So if you couldn't find one right away, what would you do?
Just go get another pair.
Do you have to sign out for them or anything?
No.
Okay. I have nothing further, Your Honor.
Nothing more for the people, Your Honor.
No, Your Honor, at this point, I believe we're prepared to proceed to closing statements.
proceed, Your Honor? Thank you, Your Honor. Well, ladies and gentlemen, you have the evidence now, and the most convincing evidence is what you just heard. Mr. Pitcher screwed up. He told you where the glove was. Maybe I tricked him into saying it, but that was his answer. His attorney didn't like that, but that was his answer. And you can take it for what it's worth. You don't have to believe it if you don't want to. But we know that the glove at the scene where there was a broken window with the DNA evidence belongs to Mr. Pitcher. And then he testified that he was without this glove for 12 days and didn't tell anybody. His attorney asked him other questions after that to say, oh, you could have gotten a glove from somewhere else. You could have done this. You could have done that. We're not here about could-haves. We're here about the evidence that we have, the exhibits that you've heard, and the testimony that you've heard. I asked you before and during voir dire, can you tell if a witness is lying or telling the truth? Does somebody have a reason to lie? You've heard a change in story on the stand. Keep that in mind when you deliberate. There's exhibits. There's no doubt about it. There's a few things that there's no doubt about. One, the stolen iPod was pawned by Mr. Pitcher. No doubt about that. And the pawn shop owner, who's in the business of doing these things, testified that his purchase of that was a steal. It's exactly what it was. It was a steal. And he knew it. Initially, when I asked Mr. Pitcher if he knew about Mr. Van Hurst's criminal history, initially he said, yeah, I heard of that. And they said, well, I just found it out today. Only after I asked him, so you knew about that when you bought the iPod. Then the story changes. Things to think about. Is somebody telling the truth or not? Of course he did. Of course he knew about it. He worked for the guy for 2 years. The guy got hooked on a home invasion while he was working with him. This was in 2010, the very year we're in right now. He was working with him when he got that home invasion. You heard that testimony. He knew about that. He knew it was stolen. All of this circumstantial evidence comes together and forms a web around Mr. Pitcher he cannot get out of. So if he's saying, I purchased it from him, and that's what you believe, convict him of receiving and concealing stolen property. If you believe, as the evidence also shows, that the DNA evidence links him to the crime scene, the description given of Mr. Pitcher by, although they couldn't identify him, yes, I saw that guy run out of the house. That's why we have trials, because there's other ways to prove that. But it does match Mr. Pitcher's description, though it's not a definite match. What is a definite match, 99 a whole lot of 9%, is the DNA that was on the glove at the crime scene that Mr. Pitcher testified was by the broken window. Think about that. He testified was by the broken window. It means he knew the window was broken and he knew where the glove was. He must have been there, right? He testified to that himself. All the other witnesses just lend support to that statement. That was the truthful part. He didn't want to answer the question that way. His attorney didn't like it, but he did. That's his testimony. So at the end of the day, I'm asking you, on behalf of the people of the state of Michigan, to choose which story you want. I think he committed the home invasion. By his testimony, he admitted that. If you don't believe that, you must believe that he committed receiving and concealing of stolen property. As the pawn shop owner told you, it was a steal. And he knew, he was working with the defendant and knew about his criminal history, what a bad guy this was. Bad guy, cheap iPod. He knew it was stolen. Mr. Pitcher either, one, knew it was stolen, or two, took it himself. The evidence can show either way. It depends what story of Mr. Pitcher's you believe. The story he told the police? Is he going to tell the truth to the police? Of course not. Not if you're guilty. Why would you? We wouldn't be here today. There would have been a plea. That's what trials are for. So you either believe the story he told the police then, and you can still convict him. Or you believe the story that he told you sitting in this witness stand when he took his right hand and swore to God he was going to tell the truth. So I'm asking you, on behalf of the people of the state of Michigan, to find the defendant guilty. Thank you.
Wow, the prosecutor liked the word testify, didn't he? You remember what the judge told us when we started about what he says and what I say? Even what I'm saying right now, it's not testimony. Our questions, our openings, our closings, we're trying to clarify for you. but it's not testimony. You did not hear Mr. Pitcher stand there and say, the glove was located here. No, you heard the prosecutor ask a question about a glove located in the home, and Mr. Pitcher answered yes. Mr. Pitcher's testimony is, yes, the glove was in the house. Prosecutor threw a few other things in. I objected. The bell was rung. It was too late. But again, that's not Mr. Pitcher's testimony. His testimony was no, in response to, did you break into the home? His testimony was, no, I would not have bought the iPod had I known it was stolen. In response to, did you know the iPod was stolen? His testimony was no to both of those. Now let's go through a few of the witnesses. Officer Adams testified it was so dark she couldn't even tell the ethnicity of the person who ran past her. Would it have been nice if the officers had caught whoever was in the home? We wouldn't have this long trial today. But it wasn't Mr. Pitcher in the home. She was aware of Mr. Van Hert's criminal history, but they didn't interview him. They weren't able to track him down. The court process server couldn't find him. He wasn't here to testify. You heard Officer Barrett testify about a boot print he found out in the mud. Well, it's a boot print he ran past. We heard no testimony as to how that boot print ties into anything other than there's a boot print in the mud. So, what did his testimony tell us? Oh, yeah, that it was so dark he couldn't tell even the ethnicity of the defendant, the person committing the crime, who it was. It wasn't Mr. Pitcher. Mr. Franklin, the shop owner, testified, yeah, I put everyone in a uniform with similar gloves, similar outfits. Here it is. You heard Mr. Pitcher testify that all he has to do is grab a new set of gloves. He lost one. How many of us want to run to our boss and say, lost something of yours, boss, when all we have to do is grab a new set and go? There's been no denial that the glove found in the house has his DNA in it. It was left in the house when he was there previously. We were not able to ask Mr. Van Hertz where he obtained the iPod. We can speculate. We're not supposed to, but we can kind of guess where it came from. But that's now, after hours of testimony. Mr. Pitcher didn't have all of this at the time. He didn't know. All the testimony you've heard today has said, maybe, kind of, if, there's a chance. The only clear testimony you've heard today came from Mr. Pitcher. And on both counts he said, no, I did not do this. No, I did not know. Ladies and gentlemen, Mr. Pitcher is innocent. He's not just not guilty. He is innocent of this crime. I know there's going to be a temptation to split the baby, to find him guilty of one and not guilty of the other. I urge you to resist that temptation. Come back, find on the evidence. Mr. Pitcher is not guilty of either crime. Thank you.
Defense counsel's right. The only clear testimony did come from the defendant. Well, not the only, but it was clear testimony that came from the defendant. Sure, when his attorney asked him softball questions, he answered them perfectly. Why wouldn't he? But when it came to tough questions, where he didn't have an answer right off the top of his head, hasn't been thinking about it, something he didn't know maybe that I was going to ask him, he didn't answer the way that he wanted to. He got caught. He got caught right here in the courtroom. That testimony is clear. He knew where the glove was. He knew the glass was broken. That means he was there. End of story. That means he broke into the house. That means he committed home invasion. You have the evidence right there. It's undeniable. that that glove is his. He didn't even deny that that glove was his. He had trouble explaining why he didn't notice he had a missing glove for 10 days or more. Trouble explaining that. He had trouble explaining the particulars, and that's, ladies and gentlemen, how you can find out if somebody's lying. And that happened right in front of you today. So again, I ask you to find the defendant guilty. Thank you.
Ready for the jury to proceed to deliberations?
No, I don't believe I'm entitled to another rebuttal, so.
I don't believe you are either, just making sure we're on the same page. Members of the jury, the evidence and arguments in this case are finished. I will now instruct you on the law. That is, I will explain the law as it applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts in this case are. That is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each witness has said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, you must follow what I say. At various times, I have already given you some instruction about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in what way to decide the case. Person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues through the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find the prosecutor has not proven every element of the crime beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful consideration, careful and considered examination of the facts and circumstances of the case. Hold on, I'm sure there's more. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in the case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. The lawyer's questions to witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you what law applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that. You are the only judges of the fact. You should decide this case from the evidence. At all times during the trial, I have excluded evidence that was offered or stricken from testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence I have let in and nothing else. Your decision should be based on all the evidence regardless of which party introduced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use personal knowledge you may have about a place, person, or event. To repeat this once more, you must decide this case based only on the evidence admitted during the trial. Would you like me to read the instruction about witness credibility? Either of you care?
I think we can
Skip it. Sounds great. The defendant in this case is charged with the crime of burglary and also the crime of receiving and concealing stolen property. To prove the charge of burglary, the prosecution must prove each of the following elements beyond a reasonable doubt. That the defendant broke and entered into the dwelling of another at night with the intent to commit a larceny. And for the second charge, to prove the charge of receiving and concealing stolen property, the prosecution must prove each of the following elements beyond a reasonable doubt. First, that some property was stolen. Second, that the defendant had that property. He possessed it, bought it, received it, possessed it, concealed it, or aided in the concealment of that property. And third, that the defendant knew or had reason to know that the property was stolen when he bought, received, or possessed it. With that, I will dismiss you to the jury room for your deliberations. And we'll come get you in a few minutes, so hurry.
All right, please rise for the jury. Well, what I
Not
didn't tell
even
you is if you
actually
find you
come.
guilty, I'm gonna set you in jail. I told you I wanna make this as real as possible. All right, go ahead and have a seat. Okay, we got a couple of, well, they're all fake juries, but two faker than fake juries. Did you guys pick 4 people for your fake juries too? Yes or no? Okay, well, someone representing the different juries stand up. All right, Clay, what was your verdict, your jury's verdict? No, I want to leave that one for the suspense for last. What? In concealing? Okay, any other jury back there? Or are you guys all on the same jury? You're on the same jury? Okay, how about this group over here, B squad? On the receiving concealing? Are you guys 2 juries or 1? Same thing as their verdict? Okay, so far they're all consistent. And how about you guys, the real jury?
Not guilty on both.
Oh! So, now would it have changed your opinion any if you knew that Officer Barrett went to the defendant's house and illegally searched it but found the boots that made the boot print in the mud where he was chasing the defendant, or now? Well, it was, but assuming it come in as evidence, assume it was a legal search and they had found because we had a whole exhibit we didn't give you guys, it got suppressed.
But he was there, he had.
Came there from the installation.
Yeah.
Whatever.
Now, as far as, and I missed this part of the testimony because I had to get on with the civil motions next door, but as far as the iPod, and I think I put in a fact pattern that Alicia testified that she bought it for $350. Because you were talking in your opening about how, well, she could pay $50, she could pay $500. But did she testify she paid $350?
No, but the pawn shop owner testified.
She did? And the pawn shop owner testified what, that he thought it was a ridiculous price or not? Because that's the one bone I did throw you.
He said it was a steal. Yeah. That was awesome.
So that didn't sway you, the $50 or $75 for a $350 iPod didn't, no?
We said if he stole it, he probably would have wanted more for it. Pawn shop would have paid more.
If he stole it, why would he, put a finger, thumbprint and go, I mean, that's just like.
You'd be surprised how many people do that. They do it in Wyoming all the time. But, they really do, I mean, I don't know how many of you know this, but the pawn shops really are required to keep track of that, and every, every week or every month or whatever, they submit a list to the police department with all that stuff, and we find a lot of stolen stuff there.